Hi, my name is Hidayat Rohani, and I'm going to talk about Thomas versus Wal-Mart Canada Incorporation case. First, let's start with the facts of the case. As I mentioned earlier, the case is Thomas versus Wal-Mart Canada Incorporation in 2006. The plaintiff is Miss Charlene May Thomas. The defendant is, of course, Wal-Mart Canada Incorporation. The counsel for the plaintiff is Richard S. Yaholinski, and counsel for the defendant, David Guerin, and the judge was, I'm not sure if I'm pronouncing his or her name right, but Chicoine. Let's talk about the key facts leading to the legal dispute. Ms. Charlene May Thomas went shopping in a Walmart store in Saskatchewan with her family and her infant daughter, where she slipped on an ice clump outside the store, and she fell on her back and hurt her hip and, of course, her back. Uh, After the incident happened, Ms. Thomas filed a complaint with the store, where the assistant manager of the store wrote down her report. But in the report, the observations were somehow conflicting regarding the ice. As Miss Thomas believed the ice clump was rather big and it caused her to slip and fall, the assistant manager to the store and other people present at the scene failed to identify any ice clump significant enough to cause anyone to fall and hurt herself. Uh, the weather condition, of course, was it was in the winter, so slight snow was present at the scene, nothing really major, and the maintenance practices were all observed by the uh, crew of the store. It meant that they did everything necessary and routine during their winter maintenance. Now let's talk about the procedural journey of the case. The initial filing and the claim was that Ms. Thomas filed for a personal injury lawsuit uh, caused by negligence of the store, Walmart store, which caused her to fall on her back and hurt herself. Of course, the defendant's response was they disputed any liability and they believed they had done everything necessary to protect the customers. After that, in the pre-trial motions, of course, many motions were filed to discuss whether the case should proceed to the court or not. After that, of course, it went to the court, and there the evidence was presented by both sides, and of course, testimonies were heard from both parties. The judge, of course, heard both testimonies and evaluated the case based on facts such as the condition of the sidewalk and whether the maintenance crew had done their job or not, and the conditions of the sidewalk in general. Of course, after hearing both sides of the story, the trial court judge delivered a judgment based on common law principles of occupiers' liability. They believe that Walmart did not breach its duty of care, and the judge concluded that the area was reasonably maintained and that any ice present did not constitute an unusual danger to any customer, including the Miss Thomas. Of course, Miss Thomas was not satisfied with the outcome of the court, therefore, she appealed to the Saskatchewan Court of Appeal. The ground for the appeal likely included arguments that the trial judge failed in applying the law or in her or his evaluation of the evidence. Of course, the Court of Appeal reviewed the trial's decision and they focused on whether the correct legal procedures and standards were met during the court, and they re-examined the principles of occupier's liability and specifics of the case, and they maintained the previous ruling. In its final decision, the court ruled in favor of the defendant, Wal-Mart Canada, and they dismissed the plaintiff's claim. The court concluded that the ice chunk that the plaintiff slipped on did not constitute any unusual danger. Additionally, the court found that Wal-Mart Canada had taken reasonable care to maintain the sidewalk, therefore fulfilling their duty of care to their customers. As a result, the plaintiff's claim was rejected. Now, the issue in this case, or better said, the issues in this case were somehow answered based on these questions. The court needed to answer the following questions to figure out what were the real issue and decide on their ruling. First, was the presence of ice chunk on the sidewalk considered an unusual danger according to established legal standards? Second, did the occupier, Wal-Mart, have knowledge or reason to know about the alleged unusual danger? Number three, did Wal-Mart exercise reasonable care in preventing injury from the alleged unusual danger? Number four, was the plaintiff, Ms. Thomas, contributory negligent in the incident? And number five, did the evidence presented meet the burden of proof required to establish liability on the part of Wal-Mart? Now, the court applied common law principles of occupier's liability in the absence of specific legislation in Saskatchewan. Key legal doctrines included the invite or invitee standard, which establishes the duty of care owed by an occupier to a visitor. In this case, the occupier being Wal-Mart Canada and the visitor being Ms. Thomas. The court also relied on the four-part inquiry proposed in another case, Maxey versus Ramsey Drugs Ltd., to determine breach of duty. First of all, unusual danger. They believe that they assessed whether the condition posed an unusual danger, which typically involves hazards not commonly encountered during the intended use of the premises. In this case, the ice clump was not deemed an unusual danger. Number two, knowledge of the danger, examining whether the occupier knew or should have known about the unusual danger. Of course, because the ice clump was not considered an unusual danger, therefore, any knowledge of that danger is not a valid excuse. Reasonable care, evaluating whether the occupier exercised reasonable care to prevent harm from unusual danger, which we talked about previously. And number four, contributory negligence, considering whether the invitee contributed to their own injury through negligence. It means that whether Ms. Thomas could have been more careful and avoided slipping on that ice clump. Now, the reasons for the holding is that the court meticulously applied the principles of occupier's liability to the facts of the case, and engaging in a thorough analysis to determine whether Wal-Mart breached its duty of care to plaintiff Ms. Thomas. Firstly, the court addressed the issue of whether the icy condition near Wal-Mart's entrance constituted an unusual danger under the inviter-invitee standard. It carefully evaluated conflicting evidence regarding the presence and size of the ice chunk. Despite some uncertainty, the court ultimately concluded that even if an ice chunk existed, its size and location did not render it an unusual danger, especially considering the sidewalk was otherwise clear and dry. This finding was pivotal in shaping the court's decision on liability. Regarding Wal-Mart's knowledge of the alleged danger, the court noted the absence of evidence linking any structural defects or recurring issues to the icy condition. Without such evidence, it seemed improper to impute knowledge of the danger to the occupier. This aspect of the analysis highlighted the importance of establishing foreseeability of the danger to hold an occupier liable. In assessing whether Walmart exercised reasonable care, the court scrutinized the maintenance program in place. It acknowledged Walmart's proactive measures, including regular clearing of snow and ice, as well as the flexible schedule for monitoring and addressing hazards. The court found these measures consistent with the standard of care expected from an occupier, emphasizing that liability does not arise solely from the existence of a danger, but from a failure to mitigate it. Lastly, the court addressed the issue of contributory negligence, though it became moot once liability was negated. Nevertheless, it noted Ms. Thomas's failure to exercise due care for her own safety, particularly given her awareness of winter hazards and the added responsibility of carrying her infant daughter. Throughout its reasoning, the court relied on established legal precedents, particularly previous slip and fall cases, to guide its analysis. It balanced the interests of both parties, emphasizing the need to uphold a reasonable standard of care while recognizing the obligations of both the occupier and the visitor in ensuring